All rise, voulez-vous le verre? The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer les fonctions résiduelles des tribunaux pénaux est ouverte. Please be seated.
Good afternoon, Your Honor. This is case number MICT-13-38 PT, the prosecutor versus Félicien Kabuga. Thank you, Your Honor.
Well, good afternoon, everyone. I'm conducting today's status conference in my capacity as the presiding and pre-trial judge of the trial chamber. And first of all, I'll take the appearances. Prosecution.
Good afternoon, Your Honour. And today the prosecution is represented by myself, Rupert Elderkin, together with our case manager, Thomas Legel, and Maria Yakusheva.
Thank you, Mr. Elderkin. And now for Mr. Kabuga.
Bonjour, Monsieur le Président. L'équipe de défense.
Good morning, Your Honor. The defense team today includes Mrs. Naori, Mr. Jacobs, and myself, Emmanuel Altit.
Now I need to be sure that Mr. Kabuga is hearing the proceedings in a language he can understand, as well as seeing the proceedings in progress. Can you confirm that, Mr. Registrar?
Ese mushobora kutubwira yuko murwumva.
Information that Mr. Kabuga is receiving the audio and the video. Thank you.
Thank you very much. Now, there is a matter I wish to discuss at the outset with Mr. Kabuga. It's confidential, and therefore I would be grateful if we could now enter into private session.
We're back in opposition. Thank you.
Thank you. For the benefit of the public, I should explain that I was indicating to Mr. Kabuga that there is no reasonable prospect of Mr. Peter Robinson being appointed as his counsel in view of the fact that he is presently subject to two judicially ordered investigations. The trial chamber has an obligation to ensure that the proceedings are both fair and expeditious, and is therefore not in a position responsibly to authorize the appointment of Mr. Robinson as Mr. Kabuga's counsel, as long as there remains the risk that the investigations could lead to a situation where he could not be able to continue to act as counsel. I have also explained to Mr. Kabuga that the trial chamber has full confidence that Maître Altit and his team are properly representing his interests. Now I will turn to matters related to trial preparation. As I have done in the past in this case, I held meetings with the parties and the registry under Rule 70G yesterday and today with the aim of eliminating procedural issues as we approach the hearing of medical expert witnesses who have been commissioned to assist the trial chamber in determining Mr. Kabuga's fitness to stand trial and for that trial to be in Arusha. To date, the trial chamber has instructed the registrar to appoint 3 independent medical experts under Rule 84 to evaluate Mr. Kabuga. The trial chamber also authorized the prosecution to appoint its own medical expert to evaluate him. All 4 medical experts have concluded their evaluations and filed their resulting reports. The final report arrived last Friday, the 6th of May, after an extension was granted to the prosecution expert. In preparation for this status conference, the parties and the registry were informed by email on 27th April that the trial chamber intended to hold a hearing of the experts in the week 30th May to 4th June. This Monday, the 9th of May, the defense filed a motion seeking the appointment of a defense medical expert to opine on Kabuga's fitness to stand trial. This motion is under consideration by the trial chamber. Yesterday, as well as today, the defense has indicated that it may not be prepared to proceed with the hearing of the experts in late May and early June due to the need to consult with additional medical experts on the complex and fundamental issues raised in the expert medical reports. The defense expects that it would be ready for the hearing in early June and intends, or may, I think, file a motion to that effect. Before I continue further, I would invite Mr. Altit to confirm or clarify the defense present position on the issue as to the timing of the hearing, and to do so on the assumption that the motion presented in writing yesterday is granted. Maître Altit.
Thank you very much, Your Honor. To answer your question, if I understood correctly, you would like to know what would the length of the hearing be. I am terribly sorry. Yes, I misunderstood. So if I understand correctly, you wish to address the fact that we would like to postpone the hearing. Is that correct?
It is correct. The question is whether you still intend to present the additional motion you referred to yesterday and today, and to seek a postponement of the hearing.
Oui, Monsieur le Président.
Yes, Your Honor. We are envisaging, as I said earlier, to file this motion for the very simple reason, and the reasons are foregoing. First of all, the question that will be put during the hearing, there's one question, one really crucial and essential question, and that is to know whether he is fit to stand trial, whether Mr. Félicien Kabuga is fit to stand trial. So we all have to prepare as best possible so that the court and the chamber understands what's going on. We believe that it is absolutely crucial to be well prepared in order not to drop anything, in order not to leave anything beside, and so that we can ensure a fair and expeditious trial. In reality, the question of a fitness to stand trial is a complex question, obviously taking into account medical reasons, but also it is a complex question which is apprehended by all of us. When we talk about the medical issues, we obviously have to take into account the various points of views of different specialists, and we really have to be well prepared. So we have to consult, which is what we have started to do. We have to consult various specialists in various different fields: neurology, psychiatry, gerontology, and there are other experts as well that we wish to consult. It is very important for us to be well prepared, in the best possible way. But I would like to add something. The discussion that we have here, if we really want to deal with this question, we really have to discuss everything in depth. It is one thing to say, yes, Mr. Kabuga can understand something, but it is another thing to know whether he is fit to stand trial. What is fitness? It is not to understand something at some point. Fitness is the capacity to create relations, to create intelligence in time, to create a projection. That is fitness, to understand what is going on. In order to determine the fitness, to our mind, it is very important to go in depth. But in order to go in depth with doctors, we have to speak their language and we have to understand what they're saying. Consequently, we have to prepare the questions that we have to put to them, to the specialists, and so this is why we believe that it is absolutely essential, and we cannot do it in a couple of days. First of all, because we do not have many days from now since the moment you have formalized your decision. If I'm not mistaken, there are 12 days between your decision and the first hearing. And second, the specialists are not at our disposal, so it is very difficult to ask us to give us their opinion. So we believe that it is useful for everybody, for the parties, but as well for the chamber. We believe that all of us here could take advantage of this, and justice will take advantage of it as well. We are therefore requesting, with all due respect, to give us an additional time of 3 weeks, which to our mind is enough to prepare the questions that we would have for them. And so the request will be filed in writing as soon as possible, because obviously we have to be very efficient. We will file it in writing in the coming days. This is all I had to say, Mr. President. Thank you.
Well, Mr. Altit, I certainly admire your oratorical skills and understand the passion with which you consider it appropriate to undertake the further investigation you seek to make. However, what you have said lacks a real degree of specific content about the particular elements of the existing reports that you would perhaps wish to challenge with the assistance of further advice. I can only, along with my colleagues, consider your application in the light of a far more specific presentation which you intend to make in writing. But I emphasize to you that the longer it takes to make it, the more difficult you make the task of the trial chamber to make a decision in your favor. It would be open to an observer to conclude that this is something that should not be being made at this stage for a number of reasons, but I leave you to elaborate on the basis for your request as soon as you possibly can. For the moment, I will maintain the current schedule without any prejudice to the decision the trial chamber takes on either your motion to appoint experts or to consult experts, or any motion you may make to seek to postpone the hearing. Therefore, and for everyone's planning purposes, it is presently expected that the experts will be examined at the Hague branch of the mechanism from Tuesday the 31st of May until Thursday the 2nd of June. The examinations scheduled are anticipated to be as follows. Firstly, Professor Henry Kennedy on the morning of the 31st of May. Then Dr. Ruta Kaile Bezosa the afternoon of 31st of May or the morning of 1st June. Then thirdly, Professor Gillian Maisie on the afternoon of 1st June. And fourthly, and provisionally, Professor Francesco Matacci Rasso the morning of the 2nd of June. It is anticipated that the trial chamber will then receive oral submissions from the parties on that evidence on either Friday the 3rd of June or Tuesday the 7th. Further instructions on the modalities pertaining to the examinations and oral submissions will be confirmed at the appropriate time and in the light of further developments in the case. Still on medical matters, the prosecution filed an urgent motion on the 27th of April requesting that their consultant medical expert be granted access to the expert medical report dated the 19th of April and filed on the record by the registrar on 21st April. The trial chamber has deliberated on this issue and grants this request. Yesterday, the prosecution asked if its consultant expert could be present during the hearings. The defense has no objection to that, and that also will be allowed. And finally, on this subject, the trial chamber orders that each of the experts that has already been appointed through judicial order in this case may now have access to all of the expert reports that have been filed on the record, as well as subsequent medical reports from the UNDU's medical officer that they have not yet received. The registrar should distribute these materials to the experts as soon as practicable. Turning now to other trial preparations. The trial chamber has issued its order on the procedure for the conduct of trial on the 14th of February and adjudicated 2 prosecution motions related to the admission of evidence pursuant to Rules 110 and 112 on the 11th and 26th of April. The trial chamber is currently deliberating on the prosecution's remaining evidentiary motions, and decisions should be issued shortly. That completes my review of the developments in this case since the last status conference. I now turn to the parties to see if there are other matters that they wish to raise. Maître Altit, is there anything else that you wish me to consider?
Merci, Monsieur le Président. Non, rien d'autre. Merci.
No, nothing. Thank you very much, Your Honor.
Maître Altit. Mr. Elderkin.
Your Honour, as an administrative matter following on from yesterday's informal meeting, we promised to put on the record our current estimate of the length of the prosecution's case in chief.
Yes.
And I know that based on the witness list filed at the time of the pre-trial briefs last August, we were looking at a case of some, I think, 168 hours. We have shaped our plan for the presentation of the evidence using the rules available. Should our intentions to file Rule 111 motions in particular be granted, then the length of the case would be around 80 hours. There was one witness I mentioned yesterday for whom we would request as a Rule 111 witness, but with a slightly extended time for their direct examination of 2 hours. Were that request to be granted, the most precise number I can give for the overall case would be 76 and a half hours.
Anything further, Mr. Eldekin?
No, Your Honour. Thank you.
Thank you for that. I'm grateful to you for looking closely at how the case might be presented to enable the trial chamber to perhaps take as relaxed as possible a view to the timekeeping necessary in view of the health considerations that have to be taken into account. Mr. Kabuga, I told you at the beginning, I noted what you had said about your own health. I'm pleased to note that you have been able to continue through these proceedings and to observe them closely. Is there anything further that you wish to say to me before I conclude this hearing?
Can you please let me go? I am very tired. I have no more strength to follow this hearing. I am very ill.
Well, Mr. Kabuga, I'm pleased to say that you will, in a moment, be free to go. That now concludes the proceedings at this status conference.
All rise. Voulez-vous le verre?